Welcome to the Nichols Tax Update podcast. Here's our regular disclaimer. I don't want to read the whole thing. I do want to call your attention to the bottom paragraph. I always acknowledge the value in preparation of this program of my subscription to Tax Notes Today. Tax Notes Today is published by tax analysts. In my opinion, the preeminent source of information for tax professionals in the United States. I look forward every day to Tax Notes Today, and I pick the things for this program from their listing of things that interest me. And I figure maybe if it interests me, sometimes if it makes me laugh, I'll share those with you. This week we have 4 items, nothing that's lighthearted in particular. Nieces and nephews are qualifying children, and that's worth a lot in our first case. And then legislation requiring practitioners to prove their competence. A prepare regulation bill is in the hopper and has strong support. I want to talk about that just a little bit. And then a question that's bedeviling new car dealers is a reduction in your new car inventory caused by the pandemic, a qualified liquidation so that it may be disregarded in your LIFO calculation. I want to talk about just a little bit and share my view from a CPA that still has a few automobile dealer clients. And then finally, how to organize a charity. I started this conversation a couple of weeks ago. We've been knocking the issues around, and I just want to share some thoughts on organizing a charity with you and ask you for your comments. Questions that you have about tax-exempt organizations, be they charitable or non-charitable, just exempt organizations, how to organize them, how to run them. Let's see if we can carry this conversation on over a period of several weeks. So let's get started. Carol Denise Griffin is an auntie. An auntie is looking after her brother's dependent children. Her brother is disabled. He really is unable to care for them in all the ways they need to be cared for. Her home is closer to their school than his home, and so there are many facts that really augur well for her to look after the children. Somehow the IRS got wind of her claiming, some disclosure she made, that she was claiming these children as her qualified dependents. And here they come with guns blazing. There was no other parent. There was no one contesting it. In fact, her brother mistakenly filled out the form that where one parent gives all the rights, a custodial parent gives a right to another parent. Well, the aunt wasn't a parent. You couldn't use that form to give her the custodial rights. She's being represented by an attorney whose bio, if you look him up, he's a public defender. He's a lawyer with a conscience, and he can't see this lady get ground up by the IRS. So away they go to the tax court with their story to tell that the aunt really looked after these children. There's lots of evidence that she was interacting with their teachers at school, a lot of evidence that they stayed with her, that she fed them, that she clothed them. There were all kinds of receipts. Based on all the evidence, it was more likely than not, according to the judge, the children resided with her for more than half the year. This question of residence is what really was settled by the evidence. What evidence? Qualifying child meets the following 4 statutory requirements. Relationship, we met that. Age, we met that. Support, she proved she supported them. But the IRS was unwilling to believe that these children could have spent more than 1/2 of the nights with Denise. Really? The petitioner credibly testified she came to tax court with her lawyer that was provided for free and testified credibly. The tax court judge said, I have no doubt that these children spent more than one-half the nights during the year, effectively saying to the IRS, get out, leave this woman alone. This was pure IRS meanness, and fortunately, this woman had access to a talented attorney to represent her in her fight for the dependency exemption, the child tax credits, and all that went with it. Regulation of preparers has broad support. The AICPA, the National Association of Enrolled Agents, H&R Block. That's quite a lineup. It's critical. It's been needed. We all know that. Melanie Loredson, the AICPA's Senior Manager for Tax Policy and Advocacy, and Jeffrey Trinka, Legislative Counsel for the National Association of Enrolled Agents, add his 2 cents worth. So what's in there? This is House Resolution 4184. Clarifying language as to the application. What does it apply to? How does it apply? And then it recites minimum competency standards for tax return preparers. You must obtain an identifying number, have to satisfy examination and continuing education requirements set by the Secretary, must complete a background check, and there's an exemption for preparers who are subject to comparable requirements and persons they supervise. So CPAs, enrolled agents, and attorneys who have been subject to comparable requirements, and the people who work for them preparing returns, hopefully under their supervision, are exempt. There's a cross-reference to Code Section 7701A36. And I've been at this a long time. I've learned that when there's a cross-reference, look it up. This is the definition of tax return preparer. The term tax return preparer means any person who prepares for compensation or who employs one or more persons to prepare for compensation, any return of tax imposed by this title, or any claim for refund of tax imposed by this title. And that's Title 26 U.S. Code, the Internal Revenue Code. That's the whole thing. Now the AICPA leads the charge for relief on the interruption of LIFO inventories. Well, the National Association of Automobile Dealers is not very far behind. The National Auto Dealers Association, the NADA. Code Section 473 provides a 3 taxable year period for replacement of LIFO layers that are liquidated due to a qualified inventory interruption. The AICPA, NADA lobbying hard to get the required notice published by the Treasury Secretary in time to benefit the calculation of 2020 taxable income in federal income tax returns of auto dealers that are on extension where there have been significant LIFO decrements as a result of the pandemic. Production of cars was virtually halted, shipment of cars was slowed down, parts weren't available, and so they can't get cars, nothing to sell. They've sold off the inventory, and those LIFO layers will not be there, or were not there, at the end of 2019. So what is in Code Section 473C2B anyway? Whenever the Secretary, after consultation with the appropriate federal officers, determines that 1, any Department of Energy regulation or request with respect to energy supplies, or any embargo, international boycott, or other major foreign trade interruption, and that's where we're hanging our hat, I added that emphasis, has made difficult or impossible the replacement during the liquidation year of any class of goods for any class of taxpayers, and that the application of this section to that class of goods and taxpayers is necessary to carry out the purposes of this section, which is to give some relief to these poor auto dealers that have had to liquidate their LIFO inventories. He, the Secretary, in the masculine, shall publish a notice of such determinations in the Federal Register, together with the period affected by such notice. It's all there. The AICPA is advocating for it, NADA is advocating for it. It's just a matter of getting our elected representatives to do what I believe is the right thing. Now, just some conversation. I don't have any cases. We do see private rulings on a regular basis where erstwhile charitable organizations or an application is denied, or an organization is thrown off tax exempt status. So I thought maybe we could just talk about this whole idea of how a charity gets organized. You need a corporation. So you organize a not-for-profit corporation under state law, but that's just the beginning. That's just the price of admission. You organize it as not-for-profit, but that doesn't mean that people can give it money and claim a tax deduction on their return. You have articles of organization of that entity that must limit the purpose of the entity to one or more exempt purposes and not empower the organization to engage in activities that do not advance one or more exempt purposes, and writing those articles of organization require the distribution of any excess funds to another 501c3 organization upon dissolution. If you don't have that, you can't get approved as a 501c3. Now, size matters. It matters because it affects which application you're going to use. Your purpose matters. Not all exempt organizations are charities. You can be exempt, and the money that you're given by your supporters simply won't be eligible for income tax deductions. You can be exempt and not be a charity. Do you expect to receive more than $5,000 per year? That affects your reporting or non-reporting. Or do you expect to receive less than $50,000 a year? That also affects how you report, and it affects the application. Maybe you need some special training. The IRS has all kinds of special training. Here's a workshop for small to mid-size tax-exempt organizations. There's the link. So you're going to organize a charity, follow the rules. First, the rules, you apply for tax-exempt status by filing the proper form. Form 1023 is the big form. That's the application for recognition of exemption under 501c3 of the Internal Revenue Code. Nothing special. You're expecting to get more than $50,000 a year in contributions. You're expecting to have significant assets. If you don't expect that, then you're going to use a Form 1023-EZ. That's the streamlined application. That must be filed electronically, and whereas the other application is, I forget how many pages, the Form 1023-EZ is only 4 pages. Then there's the Form 1024. That's the application for recognition of exemption under 501A for everything else except 501c4. Oh, wait a minute. That Form 1023 and 1023-EZ, those are only for 501c3s. You're applying for a charity, for status as charity, if you file a Form 1023 or a 1023-EZ. If you want to apply for something else other than a 501c4, you're going to use a Form 1024. So if you're applying for exempt status for a Rotary Club or a golf club, that's going to be a Form 1024. Now, the Form 1024A is an application for recognition of exemption under 501c4. Why do we need a special form for 501c4? Because the 501c4, by definition, unfortunately, is a target of abuse. The 501c4 is for social welfare, the welfare of the community, the welfare of the government, social welfare. I can organize a 501c4 to do training in, to train people on how to vote. Now, be careful, because I can't have a 501c4 that trains people on how to vote for Democrats. If I got a 501c4, it's to do some public good. So I can train young people with a 501c4. I can train young people in how to dress for work. I can train young people in how to do simple tasks. I can train high school graduates in how to convert decimals to fractions and vice versa, something we sorely need. So you need to be aware that there are these 4 different applications if you're applying for status as an exemption. Now, you want to be a charity, follow the rules. To be classified as a public charity, you got to fall within one of the enumerated categories of 501c3. Corporations, community chest, foundations organized and operated for religious, charitable, scientific, etc., fostering national or international amateur sports competitions, or the prevention of cruelty to children or animals. That's what you got to be. So we're decided we're a corporation already, right? and we organize under state law as a tax-exempt corporation. And now we're going to apply by filing a Form 1023-EZ, because we think we're going to be small. We're going to file that Form 1023-EZ so that we can be blessed, so that we can be granted tax-exempt status, 501c3 status. Now, as it happens, you incorporate, you do all the right things with your paperwork. You file the Form 1023-EZ, and you start operating as a charity. The IRS has the right to come along and audit you, and you're going to file a Form 990 every year. So you're going to do some reporting on yourself, but you're going to just start operating as a charity. You don't have to wait for permission anymore. We used to have to wait until we got the exemption letter. Not anymore. We just file the application and away we go. Even if the entity in question satisfies one of those enumerated purposes a couple of slides back, the entity cannot use the net earnings of the public charity for private purposes, private shareholder and private inurement, cannot conduct a substantial part of its activities to carry on propaganda or influence legislation, cannot participate in or intervene in a political campaign, and cannot have any part of the net earnings inure to the benefit of any private shareholder or individual. Private inurement is a constant threat where a charity is under the influence and the throes of a powerful personality. We saw that with the Trump organization. And this is not political comments. They just weren't careful. And they behaved as though there was no federal tax law, and they just did what the hell they wanted to do with the money. That wasn't following the rules. And the IRS has made that point perfectly clear. So now you're going to operate the charity. Whoa, we're going to organize the charity following the rules. We're going to operate the charity following the rules. More would-be charities are denied the status they seek or have their status revoked for operating violations than for organizing faults. So here's more IRS training. StayExempt.irs.gov. That's the best training of its kind I have ever seen. If you want to, and I would recommend it, if you're the CPA for, and you've got a board of directors that doesn't quite understand how things work, show them the IRS training. Take your computer, log on, and let these guys and gals see what the IRS training is providing. It's interactive training. If you do what they tell you to do, you'll never be in trouble. So then you want to avoid classification as a private foundation. Now, these things are not private foundations. Churches are not private foundation. An educational institution that maintains faculty curriculum, a regularly enrolled body of students, is not a private foundation. An organization whose principal purpose is to provide medical care, hospital, clinic, not a private foundation. An organization that receives its support from the United States or any state or political subdivision, a governmental unit that's owned by the United States, an organization that receives a substantial part of its support from another charitable entity, or an aquaculture research organization directly engaged in conducting research. Those are not private foundations. Is there anything else? Yes. An entity will also be deemed a public charity, and this is where the action is, if it receives more than 1/3 of its support in each tax year from a combination of gifts, grants, contributions, and membership fees, and gross receipts from admissions, sales of merchandise, performance of services, etc., to the extent that the gross receipts are the greater of $5,000 or 1% of the organization's support for the tax year in question. Now, there are things that we haven't talked about that come to bear on organizing and operating a 501c3 organization. I would like maybe next week or a couple of weeks from now, we'll talk about unrelated business taxable income. If you would like to do that, and you're part of the audience this week, let the folks at SCAPA know that you would like for me to cover that, or let me know. Send me an email, and we'll do that. We'll devote a little part of each week for a few weeks to talking about tax-exempt organizations, how to organize them, how to run them, how to stay out of trouble, how to give your clients advice, and where to get good training. So that's it for this week. Thank you. There's my email address. I really appreciate your participation. Stay safe. We all need each other here.